The meeting of the Finance and Appropriations Committee will come to order. Call the roll.
You have a quorum, Mr. Chairman.
All right, thank you. We're going to start today with the Claims Subcommittee report.
Mr. Chairman, members of the committee, the Claims Subcommittee met yesterday and heard two bills. The first bill is House Bill 1582, patroned by Delegate Sullivan. This provides about $58,000 in relief for David King Ria, which is calculated according to the formula in the statute. The subcommittee recommended reporting the bill by a vote of 3 yes, 0 no.
So moved. All right, we have a motion. Is there a second? All right. Any questions? All right, well, we will vote on the board then.
Ayes 14, no 0.
The second bill heard by the Claims Subcommittee was HB 1463, patroned by Delegate Ware. This is identical to Senate Bill 928, patroned by Senator Hashmi, and was also calculated according to the code. It's a payment of $1.5 million, and the subcommittee recommended reporting the bill by a vote of 3 yes, 0 no.
So moved. All right. Is there a second? Second. All right. If there's no further discussion, we will vote on the board.
Ayes 13, no 0, 1 abstention.
All right. Does that conclude the report? Thank you. All right. We will now move to identical bills. Go ahead.
Okay.
Yes.
Mr. Chairman, the first on the regular packet, House Bill 1525, Delegate Coiner's bill, has to do with peer recovery specialists and exceptions for barrier crimes. This is identical to Senator Favola's bill. Senate Bill 846, which passed the Senate 39 yes, 0 no.
Move to report. All right, there's a motion and a second to report. We'll vote now.
Ayes 14, no 0.
The next bill, House Bill 1526, also Delegate Coiner. This one has to do with student literacy measures, scopes for students in grades 4 through 8. It's identical now to Senate Bill 1175, Senator Lucas' bill, which passed the Senate 40 yes, 0 no, and the Senate bill includes $34.2 million in the second year to implement the staffing standard.
All right, there's a motion and a second. We'll vote now.
Ayes 14, no 0.
The next bill, House Bill 1629, is Delegate Coiner's bill, has to do with the Virginia Parent Data Portal. And
Yeah, Mr. Chair, if that could go by for the day to ensure that it's synced up with the Senate version that neither has a fiscal impact. We'll
All right.
probably have an amendment.
There's a motion to have the bill go by for the day. Is there a second? All right. All in favor say aye. Aye. All opposed, no. That bill goes by for the day.
Mr. Chair, moving to the late referrals from judiciary, which is in the blue packet. The first identical bill is House Bill 2063, Delegate Glass. This one has to do with the appointment of guardian ad litems and requested information records and reports. It is identical to Senate Bill 1144, Senator McPike's bill, which passed the Senate 38 yes, 0 no, and no budget amendment was necessary.
All right, there's a motion and a second to report. Any discussion? All right, we'll vote on the board.
Ayes 14, no 0.
Mr. Chair, the next bill, House Bill 1412, this is Delegate Marshall's bill. This has to do with adding a judgeship to the 22nd Judicial District, which was recommended by the Committee on District Courts. It's identical to Senate Bill 816, Senator Stanley's bill, which passed the Senate 39 yes, 0 no, and it was funded in both the House and the Senate budget.
Okay, we have a motion and a second to report. There's no discussion. We'll vote on the board now.
Ayes 14, no 0.
The next bill, House Bill 2317, Delegate Williams-Graves. This bill increases the jury duty allowance, and it is currently identical to Senator Sproul's bill, Senate Bill 789, which passed the Senate 40 yes, 0 no, which increases the per diem from $30 to $100. The Senate budget included the full amount at $5.3 million in the second year.
All right, is there a motion? Is this, it's already been confirmed. Yeah.
Okay.
Right. Yes.
Matt, Mr. Chair, I think it was conformed in court or in judiciary. Is that correct?
Yeah. All right, well, we don't need to conform it then if it's already conformed, so is there a motion? Is there a second? All right, we got a motion and a second to report. If there's no further discussion, we'll vote on the board.
Ayes 14, no 0.
The next bill is returning to the late referrals from Commerce and Labor. The identical bills, the first one starts with House Bill 1408, Delegate Brewer's bill, related to workers' comp and presumptions of compensability for certain cancers. It adds bladder and thyroid to the list of those cancers. It's identical to Senate Bill 906, Senator Saslaw's bill, which passed the Senate 39 yes, 0 no.
All right, we got a motion and a second to report House Bill 1408. If there's no discussion, we'll vote on the board now.
Ayes 14, no 0.
All right, that bill is reported.
The next bill, House Bill 2275, Delegate Kilgore's bill. This has to do with creating a commission on electric utility regulation. His bill was conformed to Senate Bill 1166, Senator Searle bill in Commerce and Labor, so it is now identical. That passed the Senate 21 yes, 19 no. The Senate budget included $671,000 for this to provide for full-time staff, and it did add the 3 non-legislative members to the Commission on Electric Utility Regulation.
All right, we got a motion to report. Is there a second?
One question.
Wait a second, let's get a second.
Just one.
Is
Was
there a
this-
second? Is there a second? Okay, well, okay. To Senator Peterson.
Yeah, was this the same as the Suravel bill on CEUR?
Yes.
Yeah,
Yes.
Mr. Chair.
It's already been conformed to.
Mr.
that.
Chair, this is the bill Senator Peterson voted against and spoke against.
All right.
So it's the same thing.
Thank you.
Yeah. All right, well, before we get any further down the road, let's vote on the board, so.
Ayes 11, noes 3.
All right, that bill is reported.
The next bill, House Bill 1410, Delegate Marshall's bill. This has to do with, again, workers' compensation. This adds arson investigators or bomb investigators to those that are employed by Virginia State Police. To that, it's identical to Senate Bill 1038, Senator McPike's bill, which passed the Senate 39 yes, 0 no.
All right, we have a motion and a second to report. There's no discussion. We'll vote on the board.
Ayes 13, noes 1.
All right, that bill is reported.
The next bill, House Bill 1775, Delegate Quinn's bill. This one has to do, again, with workers' comp. This one adds anxiety disorder and depressive disorder incurred by a law enforcement officer or firefighter to those compensable under the Workers' Compensation Act. It's identical to Senate Bill 904, Senator DeSteff's bill, which passed the Senate 39 yes, 0 no.
All right, is there a second? All right, we got a motion and a second. If there's no discussion, I will vote now.
Ayes 14, no 0.
That bill is reported.
Mr. Chair, that concludes all the identical bills.
All right. We'll now go to the speakers in the order in which they've reported in. We'll start out with Delegate Byron.
Thank you, Mr. Chair. This is House Bill 1887.
1887, okay.
Are you ready?
Where's 2, 3. All right, proceed.
Thank you. This is clarifying and permissive. It allows and encourages local school boards and comprehensive community colleges to enter into local or regional agreements for establishment and implementation of a competitive compensation structure to recruit and retain adjunct instructors that could be jointly compensated by those educators. This is something that I think we've seen since COVID is more prevalent now. We're still having tremendous challenges finding not only instructors, but qualified instructors. The schools are wired for broadband. It's something where Fairfax County could have a robotics class that's offered, and someone in Halifax County would be able to benefit from that through a memorandum of understanding and be able to give the flexibility to not only meet the pay of that. I know Senator Newman may be aware that Lynchburg City just did this with Campbell County this year when they had trouble getting an instructor. But some are still concerned that they don't have the authority. So this would clarify that and encourage them to get into these agreements so we can get these positions filled and be able to instruct our students.
All right. Is there a substitute that's been prepared for this?
Mr. Chairman, there is. It converts the bill to a Section 1 bill directing VCCS and DOE to convene a work group to study the matter, come back with cost estimates, and develop implementation options by November 1st, 2023.
Is there anyone who wants to make a motion?
I'll make a motion, but I'll ask the patron, have you seen the substitute?
No, I haven't. And the whole idea is for them to be able to get into their own collaborative agreements, not for the community college and someone else to come up with a price tag. The idea is to get everyone to talk amongst themselves and come up with their own agreements. And that's why it's permissive. It doesn't require anybody to do anything. And I think it's much more flexible for us to be able to do those things that we need to do. I mean, I will certainly consider what you have to say, but I don't think it accomplishes what we're trying to do.
Mr. Chair.
Yes, Senator McClellan.
Thank you, Mr. Chair. Does your bill address who hires the instructor? Because I think the concern is if the local school division hires the instructor and compensates, it could have an impact on future benchmarking of direct aid to local schools. And if the community college has an adjunct professor do that, that could affect the Affordable Care Act's 1,500 hour per year estimate. I think that's the concern, that it's unclear how that would be implemented and what impact that decision alone could have, and that the work group could tease that out and give further options to the local school divisions and the community college about the best way for them to approach who's going to hire and pay for the instructor in their agreement.
Well, once again, I understand what you're saying, and this really clarifies the fact that we have an issue with not being, that pay scale is, in many cases, not enough. It's not just a matter of sharing them across, Fairfax and Halifax County, but even Lynchburg and Campbell County to be able to come into a memorandum of understanding. They determine who's paying for what within their own parameters, and that I think that just all comes together through the memorandum of understanding. We were going to have something where there was a report back, and they could share that with the Department of Education and some of them that are already doing it, and it's been successful. They haven't needed the guidance. I don't want to interfere with what they're doing already by putting something in place that interjects that.
Mr. Chair, I'd move the substitute in order to keep this thing going.
What's that?
I'd move the substitute.
Okay, a motion's been made to adopt the substitute. Is there a second?
Mr. Chairman, I'll wait for a second.
Yeah. Is there a second on the motion? Second. All right, we got a motion and a second.
Mr.
All in
Chairman.
favor of adopting the substitute?
Before we
Or
do
you
that,
want Senator Newman.
I mean, I guess Kathy, my understanding is this would be permissive and that they could just work, we could even stay in the bill that you got to work for one or the other so you don't have a ACA problem. I don't get where the ACA is really going to be a problem. It could be something we could either add an amendment to this or say the collaborative agreements must ensure that. Is that reasonable to say?
I would agree with that.
Yeah.
And perhaps we can do that as we move forward in the process.
Okay, that sounds good. All right, is there a motion? I don't think we adopted the substitute, so all in favor of adopting the substitute, say aye. Aye. All opposed, no. All right, the substitute, all right, we have a motion to report the substitute. Is there a second? Second. All right, with the substitute. All right, we will vote now. Thank you.
Ayes 15, no 0.
All right, that's.
Thank you very
reported.
much.
Certainly. All right, Delegate Coiner.
Good morning, Mr. Chair. I have this morning House Bill 1630. My bill, as it came over, is a combination of 4 House patron bills. So we combined efforts, Delegate Bourne, Delegate Subramanian, and Delegate Bell. We all had separate VRS bills. We combined forces to bring forward what we think is a reasonable approach to getting more of our teachers back in classrooms with the teacher shortage that we have. So some of the major differences between the House and the Senate version, and we do believe that the House version will help get more teachers back into the classrooms, really has to do with not having the delayed effective date. We have a teacher shortage right now, so we would like to not have that delayed effective date. And also the sunset provision. So those are the 2 major differences. Everything else is very similar, but we feel like those differences are important to fill teacher shortages at the moment. I'd be happy to answer any questions that you have.
Okay, can you tell us what those dates are on the effective date and the sunset?
Sure. So our effective date would be immediate, and our sunset provision would be through 2028. So it's an extension of that sunset provision. The Senate version, the delayed effective date wouldn't be until January 1st of 2024, which we feel like we could go ahead and start getting more teachers back in the classroom sooner than that. And then it doesn't change the current sunset provision of 2025. So the current Senate version would start in 24 and end in 25. We're just giving it more time to see if this works, and it's helping us fill much needed classroom positions.
All right. Is there a committee substitute for this one?
Mr. Chairman, there is. It conforms to the Senate versions of the bill, SB 1479 from Senator Lucas, SB 1289 from Senator Deeds, and SB 1107 from Senator Cosgrove. It does include the specialized student support positions in Delegate Coiner's bill, but it does have the delayed effective date of 2024 and doesn't change the current expiration, and also includes some technical amendments from VRS that would allow the superintendents and the boards to identify critical shortages of those specialized student support positions.
I'll move the substitute.
All right, we have a motion to adopt the substitute in a second. All in favor, say aye.
Aye.
All opposed, no.
Move to report the substitute.
All right, we have a motion to report the substitute. You can work it out in the conference, I guess, so.
Thank you, Mr. Chair.
All right, well, was there a second on the motion to All right, we'll vote now on the board.
Ayes 16, no 0.
Thank you. All right, Delegate Les Adams, so.
Good morning, Mr. Chairman, members of the committee.
Yes.
I have House Bill 2016.
2016, all right. Page 2. Huh? Oh, blue page 2. All right, proceed.
Mr. Chairman, House Bill 2016 comes at the recommendation of the Virginia Criminal Justice Conference, which is made up of prosecutors and defense counsel who seek to address particular concerns related to the criminal law. This bill would require that in cases where there is a pending charge of aggravated murder or in particular, Class 1 felony, the mandatory punishment of life in prison, that a public defender be appointed in those jurisdictions that have a public defender, and that he be allowed a second counsel from the indigent defense counsel list. In those cases where there are no public defenders, 2 indigent defense counsels would be allowed at their request, or required to be provided upon their request.
All right, are there any questions of the patron? All right, we have a motion to report. Is there a second? Second. All right, we have a motion and a second to report. If there's no further discussion, we'll vote now.
Ayes 16, no 0.
Thank you, Mr. Chairman.
The bill is reported. All right, Delegate Rasool.
Good morning, Mr. Chairman, members of the committee. House Bill 2314.
Okay. All right, proceed.
Mr. Chairman, members of the committee, House Bill 2314 adjusts the retiree health care credit for state employees who retire with at least 30 years of service. This legislation would provide an annual cost of living adjustment identical to the annual COLA provided to Plan 2 retirees. This hasn't been adjusted since 1999, Mr. Chairman. I'm happy to answer any questions that you might have.
All right. All right, do we have a committee substitute?
Mr. Chairman, we do. The substitute removes the annual adjustment language and effective July 1, 2024, increases the amount of credit from 4 to 425.
Yes, Senator Norman.
Thank you, Madam Chairman. What does, excuse me, Mr. Chairman, what does that do to the bottom line?
I don't.
Mr. Chairman.
What's the?
Senator Norman. So you recall from last year, there was about an $80 million cash infusion to kind of reduce the unfunded liabilities of the health insurance credit for state employees. So what this does is by increasing it by 25 cents, it will increase the unfunded liabilities by $64 million, according to VRS, which basically means that it will not increase the unfunded liabilities of the health insurance credit.
Thank you.
Okay.
Yes, sir. Thank you.
All right. Is there a motion? All right. So no, we got it to substitute. All in favor of adopting the substitute, say aye. Aye. All opposed, no. All right, substitutes before us.
Mr. Chair?
Yes.
I then move to report the substitute, and I add to that some direction to the clerk to send a letter to J. Lark and VRS to study the broader issue and get a handle on.
Yeah, when it's been 24 years,
Yes.
There might be a justification for doing that. So, all right. Senator Norman.
Mr. Chair, this has nothing to do with the delegates' bill, but we're sort of flippantly sending letters to various commissions asking for studies. And the realistic question is the bandwidth of them to do that. And I realize a can do an executive committee to determine the prioritization of it. But sometimes the prioritization is not necessarily driven by merit.
All right.
And as a member of JLARC, I just offer that.
Yes. Yes.
Yeah,
Staff?
Mr. Chairman, just to add to Senator Norman's, we did speak to JLARC. He's correct. They would probably not be able to do something like this year, but they probably could the following year. So this would at least kind of put it on their list of things to look at over the next couple of years.
I would just add, Mr. Chair, and to Senator Norman, I believe they also said if you wanted it done sooner, that they could have money for a consultant and get it done as well.
Okay. All right. Well, we have the motion from Senator Deeds. Is there a second to that motion? Second. All right. There's a motion and a second to report with the substitute. We'll vote now on the board.
Ayes 16, no 0.
Thank you, Mr. Chairman. Any bill out of finance is a win, so I appreciate it. Thank you.
I move to reconsider.
He's not out of the room yet. Wait till he gets out.
I didn't hear that one, so. All right. Next one is Delegate Wiebert. See you here? Okay. All right. Delegate Watts.
Thank you, Mr. Chairman. The bill is House Bill 2411. House Bill 2411 proposes to increase the court-appointed attorney fees for representing individuals during emergency custody and voluntary and involuntary civil commissions from $75 to $120. Last changed in 25 years ago, 1998. This brings it in line with the court-appointed fees for representing misdemeanors. It was brought to my attention by Fairfax County Judiciary. We have a population of over 1 million, and we only have 4 attorneys who are available to handle these cases.
All right.
Delegate Watts,
Yes.
Mr. Chair.
Yes.
Delegate
Senator
Watts,
Deeds.
my notes say this has a, I support you. I support this idea, but my notes say it has impact of $1 million to $1.4 million. Is there any funding for that in the House budget?
Mr. Chairman, Senator Deeds, I'm sorry, but that honestly is the first time I have heard that figure. All my fiscal impact statements say indeterminate. It did pass out of Appropriations Committee, but again, there's been no impact this is the first that I've heard a specific number.
Mr. Chair.
Yes, Senator Peterson.
I noticed on our subcommittee for the Indigent Defense Commission, the governor put in several million. I'm thinking like $6 or $7 million. And maybe would this money get wrapped into the Indigent Defense Commission? I mean, is that where the pot where it's coming from?
Mr. Chair, so these are paid out of the Involuntary Mental Health Commitment Fund, IMC fund.
Okay.
We have additional information from the Office of Executive Secretary that came to light after it passed the House. Basically, we know that it's kind of looped up with other payments, and the total of those payments would be 1.4. But to answer your question, it's a different pot of funding than the IDC is paid out of.
Further question, Mr. Chair?
Yeah, Senator Peterson.
Well, I know we've also talked about putting more money for mental health funding, and it seems to me it's all part of a larger whole, that if we've allocated millions for public defenders, we've allocated millions for mental health, and yet we're not paying public defenders to cover mental health hearings. I mean, what am I missing here? I guess my question is, can we find the money?
Mr. Chair.
Yes.
Public defenders aren't the ones that defend these cases. That's a separate list.
Right.
But the money comes from IDC.
Not for this fund.
Senator Deeds.
I think
No
it was-
running battle between Deeds and Peterson.
We got to figure this out, but I think the responsible thing to do is to add the financial contingency clause.
Okay,
Bill.
and that would clarify. Is there a second to that?
Second.
Yeah. And Senator, all in favor say aye. Aye. All opposed, no. And Senator Norman.
Mr. Chairman, just because I pretend to be a lawyer, we ought to be embarrassed at the amount of compensation. This is absolutely horrific.
Right.
And we've just avoided it for too many years. And what you're finding out in the real world is you're finding fewer and fewer attorneys who are willing to remain on the court-appointed list. even if they feel like they're getting sort of a partial pro bono situation, but it really is a travesty.
All right, well, thank you for that. Yes.
And Mr. Chairman, if I may,
Yes.
I could find the quote from the judge as they interviewed a number of attorneys in Fairfax. Why can't we get more? And while it is a shorter period of time, it is extremely intense. It has a number of evening hours involved in trying to determine the case, and it's very spasmodic. In other words, how do you plan your normal practice around representing these clients when you have to devote such intensity during the period of time that these the clock is running on these hearings?
Okay, sure. Thank you for that. Is there a motion? Yeah, 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 and we adopted that. Yeah. All right. All right, there's a motion and a second. If there's no further discussion, we'll vote now. Yeah, yeah. All right.
I 16, no 0.
All right, it's reported with the amendment.
Mr. Chairman.
So thank you.
Thank you.
And we'll work on making sure that money's there, so. Yeah, yeah. All right, next, we'll go back to Delegate Wiebert. He has shown up again, so.
Thank you, Mr. Chair.
Okay, proceed.
Yes, thank you, Mr. Chair. Mr. Chair, before you is HB 1443. In short, what it does is it removes the cap on the sum of the basic aid payment for a narrow amount of localities that qualify. In reality, it applies to one locality. State supplemental basic aid is by the Code of Virginia, provides additional state funding to school divisions that serve fewer than 1,100 students, have a LCI of 6 or higher, and has 65% or more of its local taxes coming from real estate taxes. So meaning that the county largely already funds most of the school in general. And what this does is it removes the cap for that. And for the county of Rappahannock, that cap, it literally places their state basic funding aid at 2007 levels. And so this would allow increased funding to go to that locality.
All right.
And I have my superintendent here to speak to it as well.
Okay, is there any questions of the patron? All right, is there anybody who wishes to testify in favor of this proposal?
Good morning, Mr. Chairman, honorable members of this board. My name is Dr. Shannon Grimsley. I'm the cheerleader-in-chief of Rappahannock County Schools. I guess that means superintendent in other localities. As Delegate Weber has said, this cap placed on supplemental basic aid has really restricted the funding that this provision was intended to do to 2007 levels. It requires that we go out and create service sharing agreements with contiguous counties. And that cap has almost negated the cost of doing that a cost sharing agreement, which we do have with adjacent Madison County. It is a great agreement. This provision is very helpful. But the timing of this could not be more crucial for our county with the depletion of our ESSER funds, rising costs, post-pandemic education, and a very limited ability to raise revenue for our county. So I really appreciate the consideration of this bill. It will make a huge difference in our county. Thank you.
All right, thank you. Anybody have any questions for the cheerleader in charge? So, all right, thank you. Anybody else wishes to testify either for or against the bill? All right, staff, I think that JLARC is doing some review on funding issues related to SOQ, those types of things. Is there anything that you can provide us on that?
Senator Barker, that is correct. JLARC is currently reviewing the direct aid funding formulas for K-12 and should release those results this year.
All right, so that would be something that would be factored into the re-benchmarking, I presume, for the next biennial budget.
Senator Barker, I believe the JLARC report would indicate if there were any modifications that would need to be made to the funding formula.
Right.
And this supplemental basic aid could be part of that review.
All right. All right, is there anyone want to make a motion on this bill?
Report.
All right, we had a motion to report, a second, and Senator Howell, did you have?
Yeah, I didn't get to the request fast enough. It seems to me that since it is being reviewed by JLARC now and that the study will be completed this year, what we probably should do is PBI this bill and recognize that probably the report will recommend additional funding, but we don't know at this point.
I'll second.
All right.
Mr.
We have a
Chairman.
substitute motion to PBI and a second.
Mr. Chairman.
Yes, Senator Hanger.
I anticipated it might be just passed out, but since it appears it might be going the other direction, I have a couple questions that I'd like to ask before we act on that motion.
That's fine.
I carried the legislation back for Highland County, the first one of these where we had a sharing agreement so that Highland would be entitled to the same composite index as Augusta County if they worked out a sharing agreement. What is the status of the agreement with Rappahannock and Madison now?
Rappahannock has an agreement with Madison because their LCI is so high that the county is basically land rich, cash poor, and so they're literally funding the schools. The cost of the issue right now is the cost of the ongoing agreement and busing those kids and taking advantage of those programs has gotten so high that it's almost not worth doing at this point.
Okay.
And they'd like to see the additional funding so they could continue those programs so that those kids could get the additional things that they need by going to Madison and getting some of the programs there, as well as the reciprocation that they have.
And then a follow-up question, Mr.
Yes,
Chairman.
Senator Hanger.
This may be directed at staff. I'm not clear on if there's a technicality that is prohibiting them or having this capped on them in place and no one else.
Senator Barker, Senator Hanger, yes, the cap that is placed on Rappahannock is specific to them based on the legislation that was passed, I believe, in 2008. It limits the amount of supplemental basic aid to no more of the sum of the, they can't get any more of, they can't get a payment that would make their basic aid payment the same or larger than the 2007 amount. And I would note that these agreements typically were supposed to only be in place for 15 years, but the General Assembly has removed that provision on all school divisions qualifying for supplemental basic aid.
All right. Senator Hanger?
Well, Mr. Chairman, I would just express the opinion that maybe we need to address that technicality. And I'm not sure the bill is needed to do that, but it seems like we put them in a predicament because of a technicality and agreement that should have expired. Thank you.
Yep. All right. Is there any further questions or discussion? All right, we have the substitute motion to pass by indefinitely and then follow it up during the year with the JLAC report. Yeah. If there's no further discussion, I will vote on the board now.
Ayes 10, no 6.
Ayes 10, no 6. So it's
Thank you,
passed by
Chair.
indefinitely. Thank you. All right. Next, we have Delegate Wampler.
Good morning, Mr. Chair and Senators. I have House Bill 2220 in front of you this morning. That removes a one-year sunset clause that has been put on this bill every year since I've been in the House of Delegates, and I keep bringing it back.
Are you sure it's not every year since you were born?
That's right. Mr. Chair, the underlying policy under this is to allow Go Virginia grants to be matched with Tobacco Commission grants. These are two economic development entities that are set up for very similar purposes. The tobacco region, of course, is more narrow, but Go Virginia is statewide, as many of you know, and serve on the Go Virginia board. over the last 3 years, the Commonwealth has not crumbled with this law being in place. In fact, we've seen 11 projects in Southwest and Southside move forward to utilize some of these funds and have leveraged over $15 million for site development, innovation, scale up, some of the really good things that are going on in our economies. I would ask that you allow me to remove the sunset clause, but if you feel it's necessary, I'll keep showing up. Thank you, Mr. Chair.
Well, you need your exercise, so. Anyone have any questions of the patron? All right, anyone want to offer a motion?
Mr. Chair, I think there's a committee substitute, isn't there?
Committee substitute, yeah.
Mr. Chairman, the committee substitute would no longer repeal the sunset and would extend it for 1 year.
I'm making a motion. Come back next year.
All right, we have a motion and a second to adopt the committee substitute. All in favor, say aye. All opposed, no?
No.
Okay.
It's family.
Yeah. All right, we have a motion to report the bill with the substitute. Is there a second to that motion? All right, we have a motion and a second. If there's no further discussion, we'll vote now.
Thank you, Mr. Chair.
Ayes 15, noes 1.
The motion is not quite unanimously reported with a substitute. Yeah, I know. All right, next we have Delegate Durant. And then we'll come to Delegate Brewer.
Good morning, Mr. Chair, members of this committee. House Bill 1927, is that okay to go first?
Sure, that'd be fine.
All right, thank you, sir. So first I have an amendment. I'd like to introduce a technical amendment. I believe that's been submitted to staff.
Mr. Chairman, the amendment would be on line 135 as introduced. After date, we are inserting in the return or payment is received to the United States mail no later than 5 days following the time of the close of business on the last day on which such return may be filed, or such tax may be paid without penalty or interest, and this aligns the state tax component of the bill with the local component.
All right, is there a second? Second. All right, all in favor, say aye. All opposed, no. Okay, the amendment is now part of the bill. Proceed.
Thank you, Mr. Chair. This came about from an incident that happened with a constituent. A constituent who's always consistently mailed his tax payments by mail. And what we find now is that many post offices no longer postmark at the exact location. They send it to a central processing facility. And so there's no longer a reasonable expectation of when exactly you might have your tax payment postmarked. In this case, it was postmarked 2 days after the tax bill was due, but it had been mailed in a timely fashion. So we're doing a lot of digging into the code section of where discretion could be made. And speaking with the Treasurers Association found that council says that if there is discretion, we've got to have something in writing. And so what the onus is now on post offices to you've got to reach out as a constituent or someone else advocating on their behalf, as I did, and get a letter where the post office will stipulate that they've been experiencing delays. And so, right now our code section is very dependent on the postmark happening, and we are finding, in fact, that often payments are being mailed and there is no postmark, or it's illegible, or in fact it's late because it's been sent from down to a central processing facility. So working really closely with the treasurers in different localities, coming up where we will be having a reasonable expectation for taxpayers that they can get a receipt that they have mailed their tax payment in a timely fashion. So that's really the genesis of this bill, I think, to address what we can do on the state side.
All right, are there any questions of the patron? All right, anyone want to make an, yeah. All right, we got a motion and a second to report the bill with the amendment. If there's no further discussion, we'll vote now.
Ayes 16, no 0.
The bill is reported with the amendment.
Thank you very much.
Certainly.
Second bill is House Bill 2461. And so this directs all state agencies to report to the Secretary of Finance to the total fines, fees, and interest drawn imposed on individuals, businesses, and nonprofit organizations, including withdrawals and suspensions or cancellation of their licenses or certifications as a result of the Commonwealth's COVID-19 practices. So it directs the Secretary of Finance to go through a review process to reimburse up to the amount of the fine or fee or penalty paid for the violations. Just a little bit of background, we've been finding some interesting situations, including where students, college students on campuses were given $100 fines, or they were reported for honors code violations. So it's been a very interesting deep dive into this. So I hope it is a pleasure of the committee to pass this bill.
All right, are there any questions of the patron? All right. Is there anyone who wishes to speak in support of the bill? Yeah. All right. Is there anyone in opposition to the bill? All right. Okay. If there's no further discussion or anyone not wishing to testify, the floor is open for a motion.
Move to PBI.
All right. We have a motion and a second to pass the bill by indefinitely.
Mr. Chairman.
Yes.
I know that this is a difference in the budget, and I'm not one that wants to make it different between what we've funded and what they've funded, but it seems like to me that it would be a place where we could have the opportunity to put on the clause, and if there's an agreement in the budget, that maybe we could allow it, because you'd need the language to make it work. Mr. Chairman, I know that the train is moving, but I would have a substitute motion to put the clause on the bill.
All right, we have a substitute motion. And what's this? Can you repeat? Put the clause on it. Okay. All in favor of adopting that, say aye. Aye. All opposed, no? No. Okay. Ayes have it. Yes. All right, yeah.
Now, Mr. Chair, I move to PBI the bill.
Okay. We have a motion to pass the bill by indefinitely. Is there a second? Second. All right. If there's no further discussion, we'll vote now.
Thank you very much, Mr. Chair.
All right, thank you.
Ayes 10, noes 5.
All right, Delegate Brewer.
Thank you, Mr. Chair, members of the committee. I have before you House Bill 2385, which I know has been known affectionately as the Cookie Bill. This did come out of the House 99-0. We did put some floor amendment on it to clean this bill up more nicely. So we're not just targeting the People's Republic of China. We are also making it more specific to the list of federal entities that are enemies of the state. So that allowed that bill to sail out 99-0. Not that the House should have any suggestion of such. Also from DPB, there was no fiscal impact stated that DGS could not absorb.
Okay. Staff, do we have could this be conformed to Senate Bill 1459, which is Senator McDougal's bill?
I would say that I'd like to keep my bill as is. You took away some of the concerns that I think were raised in the Senate and in the House. So.
All right. If anyone wants to make a motion to conform it to Senator McDougal's fine, but otherwise the patron does not want that action. So
no, sir. There was concerns raised in the House, and the concern was that we were only targeting one specific subset, specifically the AAPI community, and we wanted to make sure that we did not do that. And so what we did with the House version on the floor amendment is we applied this to foreign enemies that there's a federal verified list of.
All right.
Mr. Chair.
Yes, Senator McClellan.
Thank you, Mr. Chair. And then, I don't have it, I'm sorry, I can't pull it up, but in your bill, does it reference a specific list that's maintained by the federal government, and if so, which agency?
So that's for anything else besides WeChat or TikTok or things of that nature. So if you look online, let me find the line here for you. On line 113, if you'd like to see my substitute, it also said Committees on Foreign Investment in the United States. So it would be the the Committee on Foreign Investment in the United States. So if you'd like a copy of the substitute, I have that.
I can pull it up, thank you.
All right, are there any other questions of the patron? Senator Peterson.
Yeah, and this is a semi-friendly, semi-not friendly question, Delegate, and we're not going to agree on this issue. But, you know, I've actually represented Chinese companies, and the way they organize companies is different. They don't have shareholders. They don't have boards of directors. You typically deal with one point of contact who is introduced as the president. And, you know, you don't really know who is actually in control. And it being a communist country, maybe the Communist Party basically has a controlling interest of every company. I don't know. And a lot of these companies are making a lot of money because they're selling products into the U.S. market. And I guess my question is, in a language that I personally don't speak, how are you supposed to know if somebody walks into my law office and says, I need a lawyer, I'm looking to do a contract so I can sell, you know, large-scale TV, large-size TVs or radios or whatever, and it's a client, and there's a demand for those services. I realize this only applies to the state, but just how exactly are we going to determine who's controlled by the Chinese government and what is just your ordinary private enterprise business? How do we make that determination?
So in the bill, they talk about scrutinized companies. I'm sure that there would be some type of assessment, but if you look on line 119 through 123 of the bill, they talk about limited partnerships, LLPs, LLCs, wholly or partially owned subsidiaries, and things of that nature. I think we can leave it up to our procurement folks to be able to properly, they do it for everything else we do in the state government, to properly scrutinize each company as they come forth.
Okay, further question. You realize that all these documents will be in Mandarin or Cantonese. I mean, this is not it's not like going onto the SEC website and pulling down a corporate charter. It's very, very different.
I don't speak Mandarin, so I can't speak to that, but I would say this, is that I think it is better that we address it and try our best to get at the heart of what the intent of the bill is, rather than to do nothing.
Mr. Chair.
Right. Senator Norman.
Thank you, Madam Chairman. Senator Peterson is a real lawyer, unlike myself. But I just shared with Mr. Chairman, I'm actually involved in some litigation on this, very similar situation. And I am an IT idiot, but I tell you, if you are persistent and diligent, it is amazing what you can find out, even if it's in Mandarin. And if you're persistent on it, that there are even English translations dealing with much of that. So persistency sometimes overcomes intellectual skill that Peterson has that I lack.
And Mr.
Yes.
Chair, to add to that thought as well, thank you, Senator Norman. To add to that also, we currently in Virginia do quite a bit, especially in the Spanish language as well. So I mean, pulling out one language over another, I wouldn't say is any different than what we probably already are doing.
All right.
Mr. Chair, if
Yes.
you know, just to repeat something that I said a little bit unsuccessfully on the floor of the Senate, I just don't think it's good practice to put names of companies in the Code of Virginia. I think it's better to describe conduct that you want to prohibit and describe it in such a way that you know, it prevents from some of these companies from changing hands. And as Senator Peterson pointed out, that Chinese society is opaque. We may or may not know who owns the company. We may or may not know what TikTok's new name is and who owns that. I just don't think it's a good idea to put these kind of names, these kind of terms in the Code of Virginia. As my friend Tommy Woodward said, please don't do that. Please don't put that in the Code of Virginia.
Mr. Chair?
Senator Barker.
Yes, Senator Brewer, and Delegate Brewer first, and I'll come to you.
Thank you, Mr. Chair.
Edwards.
To Senator Deeds' comment, I would say, so we're addressing very specifically those two applications currently, and also there's generic language as well for scrutinized companies. So we handle it both ways, just in case this could go sideways, or someone could make chat we chat, or bite dance bite, or what have you.
Yeah. Senator Edwards.
Yeah, Mr. Chair, I don't see how anybody would ever comply with this. This is beyond anybody's imagination to figure out what is a scrutinized company and all that. I can't imagine anybody the ability to comply with it. And if you do comply with it, you're going to have some pretty smart guys that spend a whole lot of time trying to figure it out. This shouldn't be in the code.
Mr. Chair, speaking to Senator Edwards' comment, so, people think it's funny that it's TikTok, but the reality is that they are a severe security threat. They've been identified federally as a security threat. Senator Warner has talked about them being a security threat. This is not a bipartisan, I think it's a nonpartisan issue to deal with national security. And so while we think it might be, comical that it's TikTok and other things, these are also getting at the heart of other companies that are wholly or partially owned through LLPs or LLCs. They're enemies of the state. And so I think it's very important that we are addressing these things. And this is also going to apply to, government devices. And I don't think with our state agencies, we want to open ourselves up and our data and our information up to foreign entities.
All right. Is there any further questions or discussion? All right, we'll open it up to a motion. Senator Newman.
Did we pass the McDougal bill? Did it leave the Senate and go to the other side?
Yes.
Mr. Chair, the McDougal bill was 2020 on the floor of the Senate. The tie was broken by the Lieutenant Governor.
Yes.
And Mr. Chair, to add to that is we did the floor amendment on my bill to make it palatable to everybody, and it passed out of the House 99-0.
Right.
Thank you, Mr. Chairman. Move the report.
Second.
All right, we got a motion and a second to report. Is there any further discussion? We will vote now.
Ayes 6, noes 10.
Yeah.
Thank you, Mr. Chair.
All right. Delegate Delaney.
Good morning, Mr. Chair and committee
I hate that
members.
you ever comply with that. I really don't.
Got HB 2150.
Yeah. All right,
So,
proceed. Yes.
Mr. Chair, this bill was brought, or this concept was brought to my attention with some of the forensic nurses that I've been working with. That's a legislative space I've delved into over the last few years, and have been privileged to serve on the task force for sexual assault, and have built some relationships with some of the forensic nurses in the Commonwealth, which sadly are too few, but that is a separate issue. What has been brought to my attention, however, is the lack of standardization when it comes to the way that nurses are able to collect evidence for victims of strangulation. We have the perks, which are the rape kits that are created by the Department of Forensic Science and distributed, and what our nurses who collect this physical evidence off of victims of crime have asked for is for the way in which they collect physical evidence from victims of strangulation be standardized in a similar way. And so what this bill does is it has the Department of Forensic Science create a standardized strangulation evidence collection kit. It will then track similarly to the perks, and then it does have a line in it as well that ensures that no victim is charged for the cost of collecting an evidence collection kit. So what we're seeing happening now, the nurses are saying they're making their own kits. So they are doing them, they are collecting the evidence, they are sending them to law enforcement, they're getting sent for analysis when needed for prosecution, but they're making them themselves. Sometimes they're opening up the perks and taking out swabs, sometimes they're just getting materials and putting them in an envelope. They're not complicated, they're a few swabs and the tool that scrapes under the nails. So they're not incredibly expensive, but having them standardized is something that these nurses are asking because it is part of their training, it is part of their practice, and they would like to see that it's done consistently across the Commonwealth so that victims of intimate partner violence, domestic violence, and strangulation can have access to justice.
All right, are there any questions of the patron?
Mr. Chairman?
Yes.
Just a comment, I'm delighted to see that the House budget actually funds this bill. unlike others.
As am I,
Yes.
Mr. Chair and Senator Howell.
I'd like to move to report.
All right, we got a motion and a second to report the bill. If there's no further discussion, we'll vote now.
Ayes 16, no 0.
Bill is reported.
Thank you, Mr. Chair. Thank you, members
Thank
of the
you.
committee.
All right, Senator, Delegate Fillicorn. So.
Thank you, Mr. Chairman, members of the committee. I believe you all have a substitute as
Right.
well, right?
We have a motion to adopt the substitute. Can staff describe the substitute?
Mr. Chairman, the substitute removes the language requiring 30 years of creditable service and increases the cap from 150 to 175, or increases the credit from 150 to 175 and the cap from 45 to 5250 solely for the local constitutional officers.
Right.
Effective July 1, 2024.
All right, proceed.
Thank you, Mr. Chairman, members of the committee. As I had the opportunity to speak with many of you, HB, as it was originally drafted, HB 1789, increased the level of health insurance retirement benefits to constitutional officers. As we know, they have been historically lower, afforded lower benefits from other state employees. And so hence came this, the idea and the concept for the bill to bring them up to parity. I understand your substitute increases the credit from $1.50 to $1.75, which would actually represent a 16% increase. And I think that's a great idea, great concept, and I believe we do have individuals here, somebody from the sheriffs, John Jones from the sheriffs, too, in support of this bill to testify, and also Joe Horble, retired Chesterfield Commissioner of Revenue, who are here to testify, if you think that's necessary, Mr. Chairman.
All right. Are there any questions of the patron? All right, is there anyone that wishes to testify in favor of this bill?
Good morning, Mr. Chairman and members of the committee. I'm John Jones, representing the Virginia Sheriff's Association, and we very much support this bill. Thank you.
All right, thank you.
Mr. Chairman, members of the committee, I'm Joe Horble with the Commissioners of the Revenue Association, and we also support the bill. Thank you.
All right, thank you. All right, is there anyone testifying in opposition? All right.
Move to report.
We have a motion to report with the substitute and a second. All in favor? Yeah. Well, if there's no further discussion, we'll vote now.
Ayes 16, no 0.
The bill is reported with the substitute. So
Thank you very much,
thank
Mr.
you.
Chairman, members of the committee.
Certainly. All right. Do we have any other bills? Okay.
Mr. Chair, the last bill on the docket for the day is House Bill 2386, Delegate Quinn's bill. It relates to the creation of a Virginia Power Innovation Fund for research and development of innovative energy technologies, including nuclear, hydrogen, geothermal, pump storage, hydropower, battery storage, and manufacturing, carbon capture and utilization. It's similar to Senate Bill 1464, Senator Vogel's bill that passed the Senate 38 yes, 1 no. I believe Senator Vogel's bill removed the nuclear.
Right.
1464, Senator Vogel's bill.
All right. A motion and second.
Mr. Chairman.
Yes.
I'm just going to hope we don't do that. The committee that heard this before thought about that and decided not to do it. It was the right move. Virginia, as you know, is on the cusp of being the nuclear leader from Lynchburg, where we have 3 of the companies. Tidewater, it's extraordinarily important. And I just hope we wouldn't do this. I think we made a mistake on the floor and taking nuclear out. It's incredibly important to a lot of us in certain areas of the state. It's extremely important, so I would hope we would not do that.
All right.
Well,
any further discussion, or yes, Senator Peterson?
And I inestimable respect for my colleague from County of Bedford. But I look at it the other way. I mean, this is general fund money we're spending, and these are large for-profit enterprises that have the ability to pay for this R&D. So if we do use taxpayer money to pay for this fund, I think it's important that we focus on those resources which are not just sustainable, but also I think environmentally friendly. And look, I'm nothing against nuclear, but I think at this point we really ought to keep this fund much more targeted.
All right. All right, is there any other comments, questions? All right, is there a motion?
Right. What's the motion?
The motion is a substitute that we conform to the action that was taken on Senator Vogel's bill. All right, all in favor of the substitute, adding the substitute there to have it be reflective of Senator Vogel's bill, say aye. Aye. All opposed, no? No. All right, we will vote on the board, so on that, chair is in doubt.
Ayes 10, no 6.
All right, ayes 10, no 6. All right. We will vote on the reporting with the substitute.
Ayes 16, no 0.
Mr. Chairman.
All right, Senator Ruff.
Yesterday, we heard from Delegate Ware, House Bill 1417, which was carried over till today. It is not on the docket. Can we take it up?
Well, as I understand it, maybe staff can sort of explain, this is a revenue bill, and so I think it is not something that we can take up today. Is that correct?
That's correct.
Mr. Chair, Senator Ruff, that bill is a revenue bill and can no longer be taken up in committee.
All right. Yeah, right, yeah. It's a long one. All right, is there anything further to come before the committee today? All right, we will be meeting tomorrow afternoon and get things to try to come close to wrapping things up. So, all right, we are adjourned.